This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, everyone. My name is Neil McBrayer. I'll be presiding today. I am joined on the panel by Judges Arnold Golden and Judge Kenny Armstrong, both of Memphis. I know you both have been briefed on the procedure this afternoon. Just a couple of reminders. First, this will be streamed live via YouTube. And secondly, should there be any technical issues, do not panic. We'll pause the proceedings, and either of you that are experiencing the issues can call in and we can get you reconnected if necessary. I understand Mr. Hill, is the attorney for the appellant. You've asked to reserve 4 minutes for rebuttal. That request is granted, so you do not need to do that as your part of your argument this afternoon. Now, there's nothing further. Mr. Hibner, if you'll call the case, please.
The law offices of T. Robert Hill, PC, formerly known as Hill Boren, PC, versus Lewis Cobb et al.
Mr. Hill.
May it please the court. Good afternoon. My name is T. Robert Hill, and I represent the appellant, Hill Boren, PC. As Harry Fallow often proclaimed, the law is never settled until it is settled right. It is never right until it is just. And is never just until it serves society in the fullest. Hill Boren brought a Rule 11 compliant lawsuit to improve and clarify the existing law, to determine the contours of the litigation privilege, to promote the adoption of rules of law that more fully serve the goals of justice, and damages for both compensatory and punitive losses suffered by Hill Boren PC by attorney as a result of attorney misconduct. At issue are the contours of the litigation privilege, the application of the doctrines of res judicata and collateral estoppel to a case that is still on appeal, aiding and abetting fraud by a fiduciary, attorney liability to a third party not in privity, and finally, the adoption of a new standard, a suggested new standard for attorney liability for harm to non-clients due to the attorney's negligence or other actionable misconduct. Defendants attempt to distinguish a difference between statutory and common law privileges and act as if the court cannot address them. But in Rye, our Supreme Court recognized that the court's responsibility to correct unworkable or erroneous court-made rules. Most of Hill Boren's claims were dismissed, relying on the litigation privilege, simply by applying the doctrine as an absolute immunity for attorney misconduct related to litigation, even intentional and criminal misconduct. In 2018, the Court of Appeals held in Reynolds versus Gray Medical that the statutory peer review privilege would not be extended to the to shield subordination of perjury. Likewise, the litigation privilege should not be extended to shield an attorney from subordination of perjury or preparing and filing false affidavits. Count 3, paragraph 47, page 37 of the amended complaint was the only allegations in 45 pages to which the litigation privilege could be said to rightfully apply. Count 3 was voluntarily dismissed by Hill Boren early on in the litigation. The litigation privilege was intended to shield attorneys from claims of defamation, whether libel or slander, occurring in the heat of litigation. The privilege should not be used to shield an attorney from liability from all forms of misconduct, such as fraud, aiding and abetting fraud of a fiduciary, conspiracy to commit fraud, suborning perjury of witnesses, or knowingly and intentionally preparing false affidavits for witnesses to sign under oath with the goal of deceiving the trial court. The cases of Simpson, Tromed, and Quantity Auto Parts, and others limit the immunity to defamation actions. Truth is the bedrock upon which justice is anchored. Any attorney who intentionally interferes with a search for truth must be held accountable, not rewarded with a get out of jail card free in the form of immunity. absolute immunity. Fraud in any form cannot be the foundation of any judicial action and must be confronted and eradicated when detected, least justice die. Let's imagine an attorney who, in the zealous ardor to win at any cost, bribes a witness to change his story about a car wreck so that the client wins. When discovered, the attorney argues that the conduct was privileged and he cannot be held accountable to the unfortunate losing wreck victim. Would we say that was just and served society to the fullest? Mr. Philo also had a couple of other sayings. One was, without liability, there is no responsibility. Immunity begets lawlessness. Now we turn our attention to the use of res judicata as the basis for the trial court's summary dismissal without discovery or trial of all remaining corporate claims. In Creech, a 2009 Supreme Court case, and in Court of Appeals decisions in Swift, Robinson, and In re Chiron, which was a Western Section case, hold that a judgment that is on appeal is not final for the application of claim and issue preclusion, such as res judicata and collateral estoppel.
Let me ask you, Mr. Hill,
Yes, sir.
in connection with those counts that the trial court dismissed based on res judicata, collateral estoppel, you arguing that that's improper because the case itself, the underlying case, is not final. You aren't arguing that the claims that you made in the underlying case are any different from the claims that you made in this case, are you?
Yes, the claims are different. If you mean by claims, the issues.
Well, I mean, for example, the breach of fiduciary duty or aiding and abetting a fiduciary duty. If in the underlying case, it was decided there was no breach of fiduciary duty, I mean, how can you prevail on an aiding and abetting a breach of fiduciary duty when it's been determined there was no breach?
Your Honor, please, I cannot. Or Hill Boren PC cannot, for the simple reason that's why the rule is such that as long as a case is on appeal, its issues and its parties cannot be decided as part of res judicata or collateral estoppel.
All right, well, let me just, I want to make certain then that what you're saying, the trial court can't rely on it because it's not final. You aren't saying that somehow the claims were different, because if you look at your counterclaim in the underlying case and your complaint in this case, the claims are the same, right?
Yes.
Okay.
And I cannot win on that issue if that is affirmed in the case that was just heard.
Okay.
And that's why, Your Honor, please, it's been extremely important that we ask the court over and over and over for a stay of this case until that case was decided. But for whatever reason, the trial court decided to move this case to the forefront to where it almost beat the underlying case, the case that's still on appeal, to the appellate level.
Mr. Hill, let me ask you a follow-up question on the res judicata dismissal. Are you saying finality is the only issue you're raising with respect to application of res judicata, or do you have some other concerns about the application of res judicata here?
I have significant concerns, Your Honor, please. This case is against lawyers who, let's say for the purpose of this argument, collaborated with their clients to commit fraud. I think the parties are different. I think the issues in certain respects are different, so that not everything.
But can a conspiracy claim, though, wouldn't you have unity of interest among all the conspirators? Alleged conspirators?
Yes, but I don't think that would apply to what do you call it? Privity of contract, that there is no privity.
But what we know for purposes of res judicata, the privity concept is not equal to that for contract. I mean, it's different.
Yes, it is different. And the court took no evidence Your Honor, please, of that thing. In other words, we got truncated in this case with a motion to dismiss that was filed within days after the lawsuit was filed and within days after the amended complaint was filed, and had no opportunity to take discovery and fill out, as we had carefully set out in the complaint, as Hill-Boren had carefully set out in the complaint, matters of great concern that we would have to do by discovery. And we knew that the fact of taking discovery from Mr. Cobb and Ms. Luna would be virtually impossible as long as the other case was pending. And these lawyers are not Ricky Boren, and that particular issue was not addressed. They simply said somehow the court made the jump that Lewis Cobb and Ricky Boren were the same. And I do not believe under res judicata that the facts will sustain that if given the opportunity to develop them, that they had a separate motive for why they were in this litigation. And Mr. Cobb and Ms. Luna and SBC's motion, which is Spraggins, Barnett, and Cobb, his motion was to destroy and assist in destroying a competitor, and that they should not have actually filed this lawsuit in the manner that they did in order to destroy a competitor with an injunction type relief that in fact did destroy Hill-Boren PC, both the brand and the legacy.
But Mr. Hill, in your underlying case, you made the claim that the plaintiffs in that case conspired with the lawyers in that case to destroy Hill-Boren, and
Yes.
that was decided against you. So how can you, in another lawsuit, bring
Your
that
Honor,
same
that
claim
issue,
against the lawyers only?
Your Honor, that issue was not in the underlying case.
The conspiracy count was not in the underlying case?
The conspiracy count included Mr. Boyd, Mr. Boren and Mr. Boyd. It
And
did
others.
not include Mr.
And others,
Cobb.
didn't it? Did it also include others? Did you
No,
specifically allege the attorneys in that lawsuit?
Yes, I believe that is accurate, Your Honor, please.
Well, so what's the difference in the underlying case? You said the parties and the lawyers conspired, and you lost on that. And now in this case, you accuse the attorneys of conspiring with the plaintiffs in the first case. How are those claims different?
Judge Armstrong, I don't think we're communicating, because Mr. Cobb was not, I was accusing Mr. Boren of conspiring with Mr. Boren and with Mr. Cobb, okay, in the other case. I was not, in that case, able to try Mr. Cobb because he was the attorney. The trial court in this case has equated Mr. Cobb, who was the attorney, and has equated that on a party stance. You know, the parties have to be the same in res judicata on the party stance. But essentially, the issue is finality, and the earlier argument showed how much trouble and how wise the minority position is on the finality issue, is that it appears that there's a wrench in the works in the underlying case, even at the appellate level. And therefore, we have ongoing litigation at two levels involving the same case. And now we have a second case where it depends on decisions made in the first case, in the underlying case, for issues of such as res judicata, collateral estoppel, or judicial estoppel. And we just simply...
Mr. Hill, your time is up.
Thank you.
You'll have your time for rebuttal. Is it Ms. Stymack? Is that correct?
Stemick, yes, Your Honor.
Stemick. Sorry, Ms. Stemick. Ms.
No
Stemick,
apology necessary.
we'll hear from the appellee.
May it please the court. Your Honors, this is a lawsuit that should never have been filed. Every claim in this case is based on the actions of Mr. Cobb and Ms. Luna that were taken in the course of representing their clients in the underlying case. every one of those claims is subject to dismissal on the basis of res judicata, collateral estoppel, the litigation privilege, and/or failure to state a claim. It's the Appellee's position that the trial court correctly found that all of those claims should be dismissed, and we ask that this court affirm the rulings of the trial court, either on the same basis or on another basis, exercising its de novo review. With regard to res judicata, I'll start with that as it was a focus in Mr. Hill's argument. There are several options that this court can take in deciding the issue involving the finality of the ultimate judgment in the underlying case. The first option is to follow the trial court's reasoning, which was that the issues on appeal in the underlying case are not determinative of the issues in this case, such that the outcome of the appeal in the underlying case would change the outcome of this case. And it is outcome based in a large component, because if the underlying case is remanded for further proceedings in the trial court, or if the underlying case is affirmed on appeal, that ruling doesn't change the fact that the issues in counts 2 and 4 that were dismissed by the trial court in this case based on res judicata were raised in the underlying case. The plaintiff had the opportunity to raise those issues in the underlying case and did raise them. As the court correctly pointed out, in the order from the underlying case, the trial court specifically identified those conspiracy and aiding and abetting claims that included Mr. Cobb and Ms. Luna by name. The claims are the same. Justice Carruthers in the Warwick case as early as 1859 wrote, "It is not material whether the finding of the jury was right or not in the former case." That was cited by the Creech Court in the context of res judicata, and it's a principle that remains true today. It brings us to focus on the public policy underlying res judicata and collateral estoppel, which emphasizes the importance of finality in litigation. We should not have multiple cases proceeding before multiple judges on the same issues. The potential for inconsistent results must be minimized or hopefully eliminated through the use of res judicata and collateral estoppel. And judicial economy is an important consideration. The defendants in this case have expended significant time and money on defending claims that should never have been brought. And the court in this case has also expended significant time. An additional option here is for the court to delay its ruling in this case on counts 2 and 4 based on res judicata until the outcome of the underlying case, and then take judicial notice of its ruling in the underlying case. A third option for this court is to find that dismissal of all claims in this case, including counts 2 and 4, is appropriate, but to select another basis on which to affirm that ultimate ruling of the trial court. That basis could be the litigation privilege or failure to state a claim, both of which were addressed by the trial court. Again, we turn to public policy with regard to the litigation privilege. Lawyers must be allowed to represent their clients without fear of being sued by an adverse party just because they win. This is a case that this doctrine is intended to prevent: lawyers being sued by the adverse party who did not prevail in the underlying case. There is an unequivocal reasonable nexus between the communications and the actions of Mr. Cobb and Ms. Luna in question and the underlying case. Mr. Hill argued that the litigation privilege is limited to spoken words and defamation claims. As we did in our brief, the appellants would refer the court to the UNARCO decision, where the litigation privilege was unequivocally extended to conduct and claims beyond defamation claims, as the trial court in this case extended it as well. The litigation privilege is an absolute privilege. It is not defeated by allegations of falsity, malice, ill will, or improper purpose. This is an important distinction from the peer review privilege that was referenced by the appellant here. The peer review privilege does have limitations. It is not an absolute privilege, and that's a significant difference. We've identified other privileges in our brief as well, including, most importantly perhaps, the purpose of each privilege. The litigation privilege is applicable here in consideration of aspects such as the capacity in which Mr. Cobb and Ms. Luna acted. There can be no doubt by the allegations in the complaint, just looking at those allegations, that all of them arise out of Mr. Cobb and Ms. Luna's actions and statements in connection with their representation of their clients. There's nothing outside that realm. There's also no substantive factual allegations to establish a basis for relief and defeat a Rule 12 motion to dismiss as to wrongful means or acting in the attorney's own self-interest rather than acting for their own clients. There are conclusory allegations, but case law tells us that conclusory allegations are not sufficient, particularly for fraud-based claims. And many of the counts here, specifically count 2, which was dismissed based on the litigation privilege, is a fraud-based claim. So the pleading requirements, especially with regard to facts, are heightened as to claims like that. There is other relief available in the underlying case for the actions that the appellant claims should not be covered by the litigation privilege. Relief available through things like a Rule 11 motion for sanctions. But the plaintiff and appellant contends that that is insufficient, and that instead the litigation privilege and the law applicable to it in Tennessee should be refined or altered by this court such that it does not protect conduct and statements that it currently protects. The Simpson-Strong tie court looked at that exact issue, pointed to those alternative remedies, and found that the limitations on the privilege, combined with those alternative remedies, were sufficient to prevent exploitation of the privilege. That has not changed. That remains the case today. This is a long-standing and well-defined principle in Tennessee law that is not in need of refining. If anything, the appellees ask that this court take advantage of this opportunity to reaffirm the importance of this privilege and its applicability to this case and others like it. With regard to the appellant's request to change existing law, that is relevant to counts 6 and 7 of the amended complaint, which were alluded to in the appellant's argument, in which a request is made to create new causes of action, to literally make new law that does not exist, that is in fact contrary to existing law, to hold lawyers accountable for actions that allegedly were taken here. There's been no sufficient basis presented to create new law under these circumstances, and so the appellees ask this court to decline to do so. With regard to count 1, which is conspiracy to breach a fiduciary duty, the trial court found that the plaintiff had failed to state a claim upon which relief could be granted for this count because there had not been a sufficient allegation of an unlawful purpose or lawful purpose accomplished by unlawful means in connection with this alleged conspiracy to breach a fiduciary duty. Again, looking at the allegations themselves in the complaint, it is clear that the purpose for which the actions taken by Mr. Cobb and Ms. Luna were taken were representation of their clients. There are not sufficient allegations to demonstrate that they were taken for any other purpose or that wrongful means were employed. Your Honor, that concludes my argument. If the court has no questions, I will thank the court for its time.
I have one question, counsel. Is it your position that all these claims could have alternatively been dismissed on the basis of failure to state a claim, or just some of those claims?
Well, Your Honor, counts 1, 6, and 7 were dismissed on failure to state a claim. Count 3 has been withdrawn. Count 5 is not on appeal. So what we're really talking about outside of the trial court's findings of failure to state a claim are counts 2 and 4. Those are the res judicata and litigation privilege counts.
Okay, and you're saying those 2 counts cannot, there's not a valid basis to dismiss those on failure to state a claim?
Actually, Your Honor, I think there is, because those are fraud-based claims, and I don't think that they've been sufficiently pled as fraud-based claims.
Okay, thank you.
You're welcome, Your Honor.
Let me ask you, if we don't have a final judgment in the underlying case, what is your suggestion about what we do with regard to counts 2 and 4 of the complaint?
Well, Your Honor, counts 2 and 4 could be dismissed on the basis of failure to state a claim because they're fraud-based and they've not been sufficiently pled. They can also be dismissed based on the litigation privilege because just as with all the other claims, they're based on actions and statements made by Mr. Cobb and Ms. Luna in the context of representing their clients, many of which are alleged to have been made literally in pleadings and in open court in the underlying case. So they fall very squarely within the context of the litigation privilege.
Okay.
Is there any other questions? Thank you very much, counsel.
Thank you, Your Honor.
We'll hear from the appellant on rebuttal.
Your Honor, I'll be relatively short. I was a little bit thrown by the fact that the lawyers got thrown into the underlying case. So I had the complaint pulled, and the complaint does not mention the lawyers in any way with regard to the compulsory counterclaims against Mr. Boren. As a matter of fact, it spells out pretty accurately that the defendant corporation sues the counter defendant Boren for $5 million in the counter thing. So I'm not sure. I know that the trial judge tried to equate Mr. Boren and his lawyer for the purposes of the party ruling in res judicata. But I don't think that's supported by the law and would argue to that. The other thing is this complaint was drafted knowing, Your Honor, that there were areas that we needed to clarify before the lawsuit would be good. And every single I was dotted and T was crossed to file a complaint that would allow discovery to fill out all the things that Ms. Stimick says there's no evidence of. Well, there's no evidence of it because we have been denied by order of the court not to do any discovery in this case. So in essence, everything was dismissed on failure to state a claim, and the res judicata only came about lately as a result of the appeal of the underlying judgment. So we think, Your Honor, please, that yes, the plaintiff in this case, Hill-Boren PC, had to file an early lawsuit, probably much earlier than it wanted to, simply because of the 1-year statute of limitations that it was faced with. It did everything in the world it could to delay having this case go to trial simply because the defendants were lawyers and simply because the other case was still on appeal and working its way up very slowly, I might add, because of the size of it. And this case really should not have gone out on motion as it did. It should have been allowed to take some discovery when it was proper to do it, which meant after the underlying case was final. And that's no fault of the plaintiff in this case. The plaintiff had to file his lawsuit because that's what the law requires, or the statute of limitations would have run on it. He had to file it under the savings statute because that also expired. So, Your Honor, please, there was really no choice at Hill-Boren PC, a corporation that's entitled to its day in court also had. But in its counterclaim, it sued Mr. Boren. It did not sue Mr. Cobb and Ms. Looney. It was only during the trial that we ultimately, when we got the transcript, that we ultimately find out that Mr. Cobb was part of the what we say the scheme in order to get this contract signed and take all the stock of Hill-Boren PC without fulfilling any of the needs of the underlying agreement, written agreement. And if there's other questions, I'd be happy to try to answer them.
Is there any other questions from the panel? Seeing none, I'll thank Mr. Hill and Ms. Stimick for their arguments in brief. The case is submitted. Mr. Hivner, if you'll recess court, please.
Thank you all.
The Honorable Court is now adjourned for the day.